Welcome to Global Online. In today's session, we will solve legal reasoning passage and MCQs from previous CLAT exams. We will focus on how to extract the legal principle, apply it correctly, eliminate wrong option, and select the most logical answer exactly as required in a CLAT exam. A new live CLAT batch is now available for students who want complete and guided preparation. This batch includes live interactive classes, updated legal reasoning techniques, topic-wise notes and worksheets, full-length mock test, regular performance tracking, and doubt-clearing support. So let's begin and sharpen your approach to legal reasoning for your CLAT exam. So first, we will read this passage. The Indian legal system places a significant emphasis on protecting the rights and welfare of children. The Juvenile Justice, Care and Protection of Children Act 2015 is a vital piece of legislation in this regard. It is designed to ensure that children in conflict with the law receive special care, protection, and treatment, with the ultimate goal of their rehabilitation and reintegration into society. One of the key provisions of the Act is the establishment of Juvenile Justice Board, that is JJB, at the district level. These boards consist of metropolitan magistrate or judicial magistrate of a first class and two social workers, at least one of whom should be a woman. The primary function of the JGB is to determine the age of the juvenile, the circumstances in which the offense was committed, and whether the juvenile should be sent to a special home or released on a probation. The Act makes a clear distinction between a child in a conflict with the law and a child in a need of a care and protection. A child in a conflict with the law is one who has committed an offense, while child in a need of care and protection is a child who is vulnerable or at a risk and requires special care and support. The Act introduces a unique approach to dealing with the children who are in a conflict with the law. For children between the ages of 16 to 18 who have committed heinous offenses, they can be tried as adults subject to a preliminary assessment by the Juvenile Justice Board. This assessment considers the child's mental and physical capacity to commit such an offense. If the board determines that the child should be tried as an adult, the case is transferred to the regular criminal courts. The Act also places restriction on the publication of information that could lead to the identification of a juvenile offender. This is done to protect the privacy and future prospect of the child. We can summarize this passage as the passage explains that the Juvenile Justice Act 2015 focuses on special care, protection, treatment, rehabilitation, and reintegration of children who came into the contact with the law. Rather than on punishment, it introduced Juvenile Justice Board at the district level composed of a metropolitan or justice magistrate of the first class and two social worker, at least one woman, to assess the age and circumstances of a juvenile and decide appropriate rehabilitative measures. The Act clearly distinguishes between child in a conflict with the law and a child in need of care and protection, and it allows 16 to 18-year-old accused of heinous offenses to be tried as an adult after a preliminary assessment by the JGB, while also restricting publication of details that could reveal a juvenile's identity to safeguard their privacy. So we have first question here: what is primary objective of the Juvenile Justice, that is Care and Protection of Children Act 2015? So the question is asking about the main aim of the act as described in the passage, not any side feature or general child right goals. So in the first paragraph, the passage states that the act is designated to ensure special care, protection and treatment for children in a conflict with the law, with the ultimate goal of their rehabilitation and reintegration into the society. So we have options here. Option A, to punish child offender. This is opposite to the passage emphasis. The act is reformative, not punitive, and focuses on care and rehabilitation instead of punishment. In case of option C, to remove all form of violence against children. This is too broad and is not stated as the specific objective of this act in this passage. The focus is on children in a conflict with the law and their rehabilitation, not on all forms of a violence in a general. While in case of a D, to increase the age of a criminal responsibility, the passage does not mention any change in the age of a criminal responsibility. Instead, it discusses how 16 to 18-year-olds may be tried as adult in heinous offenses after the assessment. But in case of option B, to rehabilitate and reintegrate children in conflict with the law, this matches the ultimate goal expressly mentioned in the passage, rehabilitation and reintegration into the society. So option B is the correct answer here. We have next question, who makes up the Juvenile Justice Board, that is JJB. So the question asking about the composition of a JJB as given in the passage, exactly which members from the board. So in the second paragraph, the passage states that the JJB consists of Metropolitan Magistrate or Judicial Magistrate of the first class and the two social workers, with at least one being a woman. So in case of option A, two judges, the passage mentions only one magistrate plus two social workers, not two judges. So this is a factually incorrect. In case of option B, a metropolitan magistrate and a two lawyer, the passage specifies two social worker instead of two lawyers. So this is not match the given composition. In case of option D, three police officers are not mentioned as a member of a JGB in the passage. The board is a judicial plus social worker based. So this one is a wrong option. While in case of option C, a metropolitan magistrate or a judicial magistrate of a first class and two social workers, this option precisely mirrors the description in the passage, including the magistrate plus two social worker. So option C is the correct here. Next question is, what is the role of a Juvenile Justice Board, that is JJB? So this question is asking what the JJB actually does according to the passage, its key function, not just any general power. So the second paragraph explains that the primary function of the JJB is to determine the age of a juvenile, understand the circumstances in which the offense was committed, and decide whether the juvenile should be sent to the special home or released on a probation. There are all assessment and rehabilitation oriented functions. So in case of option A, to determine the punishment for juvenile offenders, the passage does not say the JJB determines punishment. In a penal sense, it stresses assessment and deciding on rehabilitative measures like special homes or probation, not punitive sentencing. That's why option A will be wrong here. In case of option B, to decide whether a child should be sent to a regular prison, the passage never mentions regular prison as an option before the JGB. Instead, it speaks of social homes and probation, which are child-friendly alternatives. In case of option D, to prosecute child offenders, prosecution is a function of the prosecution or a state, not the JJB as described. The board's role is adjudicatory and rehabilitative, age and circumstances assessment, placement decisions, not to act as a prosecutor. In case of option C, to assess the age and circumstances of the juvenile and make decision on rehabilitation. This one matches with the passage directly. Determine age, examine circumstances and decide on special home or a probation, which are form of a rehabilitation. So option C is correct here. Next question is, what is the distinction between a child in a conflict with the law and a child need of a care and a protection? This question tests whether you can differentiate between two categories of children as defined in the passage. In the third paragraph, the passage clearly states that a child in a conflict with the law is one who has committed an offense, whereas a child in need of a care and protection is a child who is vulnerable or at a risk and requires special care and support. So in case of option A, there is no distinction. Both terms mean the same thing. This directly contradicts the passage, which explicitly says the act makes a clear distinction between two categories. In case of option C, a child in need of a care and protection is more likely to commit crimes. The passage does not say anything about likelihood of committing crimes. It describes this child as a vulnerable or at a risk and needing care, not as more likely to offend. In case of option D, a child in a conflict with the law is an adolescent of. This statement is incomplete and even If interpreted, the passage focuses on the fact of having committed an offense, not merely age or adolescence. So this does not match the definition. Option B, a child in a conflict with the law has committed a crime while child in need of care and protection is vulnerable or at a risk. This restates the exact distinction given in the passage, offense committing versus vulnerable, at a risk and needing care. So option B is the correct answer here. First, we will read this passage. However, determining whether an intermediary has fulfilled its due diligence obligations can be complex. The Indian judiciary has been actively interpreting this provision. One significant case is the Shreya Singhal versus Union of India, in which the Supreme Court clarified that intermediaries are required to act upon a valid court order or government directive for content removal, not upon private complaints. The court also emphasized that the intermediaries should not take a proactive role in monitoring content, as this could potentially infringe on a free speech. While the law provides a safe harbor, it does not absolve intermediaries from their responsibilities. Online defamation cases often involve a balancing act between the right to freedom of expression and the right to reputation. The Indian legal system requires a careful examination of the content, context, and intent of a statement to determine whether they qualify as defamatory. Additionally, the plaintiff in an online defamation case must prove that the statement was a false, damaging to their reputation, and made with a degree of a fault such as negligence or actual malice. So we can summarize this passage as the passage explains how Indian law handles online defamation and the role of intermediaries like social media platform and websites. It discusses section 79 of the IT Act 2000, which gives intermediaries safe harbor protection if they meet due diligence requirement, and clarifies through the Shreya Singhal versus Union of India judgment that they must act on a valid court orders or government directives, not a private complaints, and are not required to proactively monitor content. It also explains that online defamation cases involve balancing freedom of expression and the right to reputation, and that a plaintiff must prove the statement is a false, harms reputation, and was made with some fault, that is negligence or malice. So the question is, what is the primary focus of the passage? So students, this question wants the central theme of the entire passage, not a side point or one example. So the passage talks about intermediaries, due diligence, safe harbor, Shreya Singhal, and how courts assess online defamation, including elements like falsity, harm to reputation, and fault, all in the context of online defamation. So option A, the rise of a social media in India. The passage does not discuss growth of social media, usage statistics, or trends. It is about legal treatment of online defamation. In case of option C, the role of intermediaries in online content. Intermediaries are discussed, but only as a part of a broader issue of online defamation. This is a sub-theme, not the main focus. In case of option D, the importance of a free speech on the internet. Free speech appears one right to be balanced, but the detailed focus is on defamation rules and standards, not a general essay on free speech. In case of option B, the legal aspects of online defamation in India. This captures everything: safe harbor, court interpretation, balancing of rights, and what plaintiff must prove in online defamation. So option B will be the correct answer here. Next question is, what is online defamation as described in the passage? So this question is asking for the meaning of online defamation according to the passage. So the passage states that online defamation cases involve examining content, context, and intent to see if statement qualify as a defamatory, and adds that the plaintiff must prove the statement was false and damaging to the reputation. So in case of option A, making harmful statement about someone in a person, this is offline face-to-face defamation, whereas the passage is about statement made on the internet. In case of option C, online harassment, this harassment is a broader and mainly include repeated conduct threats. The passage specifically focuses on false reputation damaging statements. Option D says a form of political activism Political activism can involve speech but is not by definition, while in case of a defamation, the passage never defines defamation this way. So option B, false statement made on the internet that harms someone's reputation. This matches the description online, false and damaging to the reputation. Hence option B will be the correct answer here. Next question is, what is the significance of a section 79 of the Information Technology Act 2000 as mentioned in the passage? So this question is asking about section 79 does in this context, not everything about the section. So the passage mentions that the law provides safe harbor to intermediaries but does not completely absolve them, and this safe harbor is under section 79 of the IT Act 2000. So option A, it defines defamation laws in India, but defamation law is largely in the IPC and tort law. The passage ties section 79 to intermediary protection, not the definition of the defamation. In case of option C, it regulates the content on social media platform. The passage does not say section 79 regulates content. It grants a conditional immunity or a safe harbor to intermediaries. In case of option D, it allows private complaints against online defamation. The passage specifically says intermediaries are to act on court orders or government directives, not private complaints. So in case of option B, it provides a safe harbor for intermediaries in case of online defamation. This is exactly the significance explained. Intermediaries get protection or a safe harbor if they fulfill due diligence. Hence option B will be the correct answer here. Next question is, according to the Supreme Court in a Shreya Singhal versus Union of India case, under what circumstances should intermediaries act in response to content removal? So this question is asking, when must intermediaries act to remove content as clarified in this specific case? The passage states that in Shreya Singhal, the Supreme Court clarified that intermediaries are required to act upon a valid court order or government directive for content removal, not upon private complaints, and that they should not proactively monitor content. So option A, upon receiving a private complaint, the passage explicitly rejects this and says not upon a private complaints. In case of option C, proactively to monitor content, the court emphasized that intermediaries should not take a proactive monitoring role. In case of option D, only if the content is found to be defamatory, the trigger mentioned is a valid court order or government directive, not the intermediary's own findings of defamation. But in case of option B, upon a valid court order or a government directive, this directly reflects the Supreme Court's clarification. So option B will be the correct answer here. Next question is, how does the Indian legal system balance the right to freedom of expression and the right to a reputation in online defamation cases? So this question is asking about the method of balancing these two rights in online defamation disputes. So the passage says that online defamation cases involve a balancing act between right to freedom and expression and the right to reputation, and that the legal system requires careful examination of content, context, and intent to determine if it is defamatory. So in case of option A, by favoring freedom of expression over reputation, so no such preference is stated. The passage speaks of balancing, not automatically privileging one right. Option B, by favoring reputation over freedom of expression, again nothing indicates a one-sided bias. The process is analytical and fact specific. In case of option D, by absolving intermediaries of their responsibilities, this passage explicitly says a safe harbor does not absolve intermediaries of all responsibilities, and this has nothing to do with the balancing of the two rights between parties. But in case of option C, by carefully examining the content, context, and intent of a statement, this is exactly what the passage says. The court do not decide if the statement is a defamatory, thus balancing both rights. Hence, option C is correct answer here. Next question is, in an online defamation case, what must the plaintiff prove about the defamatory statement? So this question is asking for the specific element the plaintiff has to be established in a such case. So the passage says the plaintiff must prove that the statement was a false, damaging to their reputation and made with a degree of fault such as negligence or actual malice. So the option A, that it was political activism, the passage does not mention political activism as an element to be proved. In case of option B, that it was made with the good intentions. In this case, the opposite is relevant, a degree of fault, negligence or malice, not good intentions. In case of option D, that is what true and intended to inform the public, this truth generally defeats defamation. Here, the plaintiff must show falsity, not a truth. In case of option D, that is was a false, damaging to their reputation and made with the degree of fault, this restate the passage almost verbatim, falsity, reputational harm and fault, that is negligence or malice. So option D is correct answer here. Next question is, what is the role of intermediaries in the context of online defamation cases? So this question is asking how intermediaries are supposed to behave in these cases according to the passage. The passage says intermediaries have safe harbor but not total immunity, must act on valid court orders or government directives for content removal, and should not proactively monitor content. So option A, to actively monitor and censor content, the passage explicitly says they should not take a proactive role in monitoring content. In case of option B, to act upon private complaints for content removal, the passage clearly distinguishes this and says they are not required to act on a private complaints. In case of option C, to completely absolve themselves of a liability, this states that while there is a safe harbor, it does not absolve intermediaries of responsibilities. They still must comply with the valid orders. In case of option D, to encourage online defamation, this is contrary to the idea due diligence and responsibilities. Nothing in the passage suggests this. So none of the option accurately describe the role as per the passage, but if forced within this set, the best interpretation is that the question is incomplete or miskeyed based on strictly on the text. The expected correct idea, though not listed, would be to comply with the valid court or government orders while not proactively monitoring content. Hence, no option seems to be correct here. Such type of question might get withdrawn by consortium after the publication of the answer key. So let's read this passage. The editor guide of India has exposed concern over the draconian provisions of the press and registration of periodicals, that is PRP Bill 2023, that can have an adverse impact on freedom of the press. The Guild added, Editors Guild of India would like the proposed bill to ensure that publishing of news in India remains free of encumbrance and intrusive checks on publishers by the registrar, and the primary emphasis of the registrar and PRP remains registration and not regulation, as the latter has the potential of restricting freedom of the press. In the definition section, the term specified authority gives the power to government agencies beyond the press registrar to conduct the function of the registrar, which could even include police and other law enforcement agencies. Given the intrusive, expansive, and vague nature of powers that the bill in any case allows to the press registrar, the power to further delegate this power to other government agencies, including law enforcement agencies, is deeply distressing. The Guild said, the statement says section 4.1 and 11.4 allow the registrar to deny the right to bring out a periodical and cancel the certification of registration of the periodical to person convicted of a terrorist act or unlawful activity, or for having done anything against the security of the state. Interestingly, the PRB Act 1867 had no such provisions, given the liberal and arbitrary use of UAPA, which is the basis for defining terrorist act and unlawful activities, as well as other criminal laws, including sedition against journalists and media organizations to suppress freedom of speech. The Guild is deeply concerned by the introduction of these new provisions and the way they can be misused to deny the right to bring out news publication to persons who are critical of governments. It said, among the other worrisome provisions listed by the guild is section 6b, which gives power to the press registrar as well as any other specified authority to enter the premises of the periodicals to inspect or take a copies of the relevant record or document as asked any questions necessary for obtaining any information required to be furnished. So in short, the passage explains why the Editors Guild of India is worried that the press and registration of the periodicals, that is PRP Bill 2023, could seriously harm press freedom. The guild object to powers given to the press registrar and specified authorities, including possibly police and law enforcement agencies, to deny or cancel registration, enter premises, inspect record, and restrict those convicted under the law like UAPA and sedition from publishing. Because such vague and intrusive power can be misused against journalists critical of the government, the Guild argues that the registrar's role should remain limited to registration, not regulation, as a regulatory power and punitive power in the present political legal context can chill free speech and undermine the freedom of the press. So we have a question here. The PRP bill defines newspaper to mean a periodical of loose folded sheets usually printed on a newsprint and brought out daily or at least once in a week, containing information on current event, public news, or comments on a public news. Who among the following is covered by the definition of a newspaper? So students, the question asking which option fits the statutory definition of a newspaper in the PRP bill: loose folded sheet, printed on newsprint, brought out daily or at least weekly, carrying current event, public news, or a comments. So the question itself gives the definition: a periodical a periodical of a loose folded sheet printed on newsprint, brought out daily or at least once a week, with current event or public news or comments on a public news. So option A, Mr. X publishing news content on digital media. So this digital content is not loose folded sheet printed on a newsprint, so it falls outside this definition. In case of option B, Mr. Y publishing books containing the comment of a public on public news. So books are not loose folded newspaper sheets and are not periodicals brought out at least weekly in the ordinary sense used here. In case of option C, Mr. Z publishing news content in a print media on weekly basis. This matches print media on newsprint, weekly periodicals and news content, so option C fits the given definition. Hence, option C will be the correct answer here. Who among the following is not eligible to publish a periodical as per the PRP bill? So this question is asking whose right to publish is barred under the bill's disqualification clause, that is denial or cancellation to persons convicted of a terrorist act or unlawful activities or for acts against the security of the state. So the passage states that section 4.1 and 11.4 allows the registrar to deny or cancel registration for person convicted of a terrorist act or unlawful activities or for having done anything against the security of the state. So option B says Mr. B accused of unlawful activities under UAPA. The passage talks about persons convicted, not merely accused. Accusation alone does not fit the text. In case of option C, Mr. C accused of terrorist activities under UAPA. Again, only convicted persons are explicitly targeted in the quoted clause. Mere accusation is not enough. In case of option A, Mr. A convicted of waging war against government of India. So the waging war is an offense against the security of a state. The passage says persons convicted of an act against the security of the state can be denied registration. Hence, Mr. A falls squarely within the bar. Hence, option A will be the correct answer here. Next question is, which of the following is a threat to the freedom of a press in India? So this question is asking which listed situation as per the passage and its context actually threaten press freedom. The passage highlights liberal and arbitrary use of UAPA and other criminal law, including sedition against journalists and media organization to suppress freedom of speech as a major concern. So in case of option C, levy of GST on newspapers, the passage never refers to taxation as a threat, its concern is criminal law and regulatory powers being used to curb speech. In case of option A, liberal use of UAPA against journalists, this matches the passage's warning about liberal and arbitrary use of UAPA against journalists to suppress freedom of speech. In case of option B, use of sedition laws. In case of option A, liberal use of Unlawful Activities Prevention Act against journalists refrains journalists from tracing, tracking, and publishing investigative articles because they apprehend that they might be linked with the criminals. So this matches the passage's warning about liberal and arbitrary use of UAPA against journalists to suppress freedom of speech. In case of option B, use of a sedition law against journalists under the guise that through their articles they are promoting hatred and exciting disaffection against the government. This passage explicitly mentions sedition being used against journalists and media organizations to suppress freedom of speech, since both A and B reflect the threat discussed in the text. Hence, this combines the two practices that the passage itself treats as dangerous for the press freedom. Hence, option D, both A and B will be the correct answer here. Next question is, the PRP bill defines specified authority to mean a district magistrate or collector or such other officer as the state government, or as the case may be, Union Territory Administration may by notification specify. The PRP bill is criticized by editor Guild of India because this question asks which stated reason align with the Guild's criticism about the breadth of powers of specified authorities and the registrar. So the passage itself says specified authority can include government agencies beyond the press registrar, possibly police and other law enforcement. The registrar already has intrusive, expansive, and vague powers. Power included denying and cancelling registration and entering premises to inspect records. In case of option A, the definition of specified authority is too wide and can include even officers below the level of collector. The PRP bill enables the specified authority to perform the functions of a press registrar general. This reflects the concerns that power of registrar can delegated to other agencies, including law enforcement, making the definition too wide and intrusive. In case of option B, the PRP bill confers various powers on the press registrar general, including the power to register, deny registration, cancel the registrations, etc. So the passage explicitly notes the bill allows denial and cancellation of certificate and criticize the intrusive nature of these powers. In case of option C, the PRP bill enables the specified authority to enter the premises of periodical for inspection. So the passage labels section 6B as a worrisome because it allows the registrar or specified authorities to enter premises and inspect or copy records. Since all three are part of a guild's critique, hence all of the above, option D best captures the full set of objections described. Hence option D will be the correct answer here. Next question is, freedom of the press is not specifically guaranteed under the Constitution of India but is implied in Article 19(1)(a), freedom of speech and expression. Therefore, freedom of the press is a part of a fundamental right. So students, the question is asking for which statement correctly applies constitutional doctrine press freedom as a facet of Article 19(1)(a) but subject to reasonable restrictions. The passage reminds that press freedom can be restricted through laws like PRP bill and criminal status, UAPA and sedition, and that the guild is concerned about misuse, not about the impossibility of regulation itself. It implies that regulation is possible but must not be arbitrary or excessive. So option A, no law can be made for registration and denial of registration of newspaper. This is incorrect constitutionally. Fundamental rights are subject to reasonable restriction and regulatory law, including registration, do exist. In case of option C, journalist and press is exempt from general criminal laws. This is clearly wrong. The passage itself discusses journalists being proceeded against under UAPA and sedition. The problem is misuse, not total exemption. In case of option B, fundamental rights are not absolute right and reasonable restrictions can be imposed on the exercise of fundamental rights, and therefore laws such as PRP bill can be enacted. So this aligns with the constitutional doctrine press freedom is a fundamental right but not absolute. Reasonable restrictions by law are permitted, which is way such a bill can exist, even if its draconian features are criticized. Hence, option B will be the correct answer in this case. So we have a passage here. There are some advantages of the Digital Personal Data Protection Act 2023. For instance, for the first time, personal data belonging to or identifying children will have to be classified separately with such data carrying a greater degree of security and privacy. The law also seeks to reduce the rate and impact of data breaches targeting Indian businesses. The Digital Personal Data Protection Law, however, goes a step beyond by imposing penalties for the cases where the data is breached as a result of lack of implementation of adequate security control. However, it could be said that the law isn't balanced because it provides wide exemption to the processing of personal data to the government. For instance, data can be processed in the interest of prevention, detection, investigation, or prosecution of any offense in India. These kind of exemptions are dangerous as they stand to legitimize widespread and unwarranted collection of data under the guise that such collection and processing may ultimately be useful for preventing or deterring a crime. Security agencies will have significant authorities to collect and retain any data whatsoever, as is typically the case with exemptions relating to the maintenance of sovereignty, integrity, security of the state, prevention of public order, prevention of offenses, and incitement to commit offenses. The law also exempts processing of personal data held outside of India. The government is also exempt from being required to delete any data that is processed regardless of the purpose it may have been collected for. On the request of any individual or by way of a prescribed data retention period, the government is not bound by purpose limitations, allowing data collected for one specific purpose be used for a new incompatible purpose, which stands in contrast to the regulations imposed on the business. So this passage outlines both the protective and problematic aspects of a Digital Personal Data Protection Act 2023. It highlights a positive like stronger safeguards for children's data and stricter penalties on businesses for data breaches, but then stresses that wide exemptions for government processing on ground like crime prevention, security of the state, sovereignty, and public order allow extensive collection, retention, and reuse of a personal data without deletion, purpose limitations, or territorial limits, creating serious risk of surveillance and misuse is under the guise of security and research. So the first question is, Mr. Lal was suffering from a rare disease that the data relating of that was collected by the government. Suppose the DPA 2023 provides exemption for the government relating to data deemed necessary for research, archiving, or statistical purpose. If the personal data is not to be used to take any decision specific to a data principle and such processing is carried on accordance with such standards as may be prescribed. So which of the following is most appropriate? Basically, the question asks how Mr. Lal's health data may be used or preserved when there is a specific research exemption. Data may be processed for research, archiving, statistic if it is not used to take any decision about a data principle and is processed per prescribed standards. So the passage says the data gives broad exemption to government processing, including for purpose like prevention, detection, investigation, and similar public interest ground, and mentions that government is exempt from deletion and purpose limitation. The hypothetical adds an explicit research exemption as long as no individual specific data is taken. So in case of option B, the data can only be used for taking any decision regarding Mr. Lal. This contradicts the stated condition that under the exemption, the data is not to be used to take any decision specific to a data principle. So this is the opposite of what is allowed. In case of a next option, that is option C, the personal data of Mr. Lal's health condition and his personal data can be preserved by the private hospital forever and used for research by them without his consent. So the scenario describes an exemption for government, not for private hospital, and does not authorize forever retention and research without any safeguards or consent in the private setting. In case of option A, the personal data of Mr. Lal can be preserved by the government till the research on rare diseases is completed. So this fits the described research archiving exemption. The government can preserve and process data for research purpose, not for taking individual decisions according to the prescribed standards. Hence, option A will be the correct answer here. Next question is, suppose the DPA 2023 provided exemption for the processing of personal data for the purpose of ascertaining the financial position of any person who has defaulted in payment of amount due to loan taken from nationalized bank. Mr. X commits a default in repayment of EMI of loan taken from nationalized bank. So this question is asking which kind of data processing is justified when there is an explicit exemption allowing processing of personal data for the purpose of ascertaining the financial position of a loan defaulter. So the passage stresses that the exemption are tied to a specific purpose, means prevention of offense or a security of a state. The hypothetical gives a purpose-based exemption ascertaining the financial position of a defaulter. So in case of option A, the bank can demand access to any process the personal data of Mr. X relating to family history of alignments from which Mr. X or his family was suffering. So medical or alignment history is unrelated to ascertaining financial position. It does not logically help determine assets and liabilities. In case of option B, the bank can process the personal data of Mr. X wise Mr. X, the particulars of family, wife, children, brothers, etc. So purely demographic family composition data without connection to the assets or liabilities goes beyond what is reasonably necessary to a certain financial position. In case of option C, the bank can process the data of Mr. X for the purpose of ascertaining the assets and liabilities of the defaulter. So this directly serves the given exempted purpose. Knowing his assets and liabilities is exactly what financial position implies. Hence, option C will be the correct answer here. Next question is, suppose Mr. Y, a citizen of India, is working in a MNC in New Zealand since 2021. The MNC has obtained personal details of the employee for the purpose of recovering the amount of indemnity bond if Mr. Y left the job within 3 years of joining. So this question asks whether and how DPA applies to an Indian citizen's data when processed outside India by foreign MNC and whether timing or location of data storage matters. So the passage notes that the law also exempts processing of personal data held outside of India, highlighting both territorial and government side exemptions. The hypothetical wants you to see that data held outside India is outside DPA's scope. So in case of option A, Mr. Y can file an application in India for protection of his digital personal data under the DPDPA if he leaves the job in September 2023 and returns to India. So this assumes DPDPA governs that foreign held data. The passage states personal data held outside India is exempt. So this protection route is misplaced. In case of a next option, that is option B, Mr. Y being a citizen of India can claim protection against the MNCs for misuse of his personal data even while serving in New Zealand. So citizenship alone does not override the territorial exemption mentioned. The issue is where the data is held or processed. In case of option D, the DPA 2023 is not applicable since the data has been obtained before the enactment date of a DPDPA. The passage does not frame inapplicability of a purely temporal grounds. The key text says exemption for data held outside India. While in case of option C, the DPDPA 2023 is not applicable since the data is held outside India. So this tracks the passage's explicit exemption for the personal data which is held outside India. Hence, option C will be the correct answer in this case. Next question is, if personal data is defined as any data about an individual who is identifiable by or in relation to such data, which of the following shall be classified as a personal data? So this question is asking which of the listed items qualify as personal data under the definition any data about an individual who is identifiable by or in relation to such data. So the question itself supplies the definition. In the passage discusses personal data in the sense of identifiable information about individuals, that is health and financial records, etc. So option A, name of a person, a name clearly identifies an individual. In case of option B, full residential address, this can directly identify where a specific person lives, thus identifying them. In case of option C, Aadhaar number, a unique government issued identifier that directly pinpoints the individual. So all three independently makes a person identifiable. So option D, all of the above, this correctly groups all three as a personal data. Hence option D will be the correct answer in this case. Next question is, in which of the following cases the access to personal data shall be granted and the person whose data is accessed and processed cannot claim personal data protection. So the question asks, in which situation access to personal data is allowed under typical public interest exemption so that the individual cannot successfully invoke personal data protection to block it. So the passage states that the law gives government-wide exemption to process data in the interest of prevention, detection, investigation, or prosecution of offenses, securities of state, personal public order, and prevention of offenses, giving security agencies extensive authority. Mr. Z has committed many robberies and police wants to access his Aadhaar detail and fingerprint data for the purpose of tracing Mr. Z. So this fits prevention, detection, investigation, or prosecution of any offense using identifier to trace robbery suspects falls squarely within that exemption. In case of option B, it apprehends that a person identified as a Mr. G would spread hatred among various communities, which would lead to riot, and police intends to use the mobile number and the personal details of Mr. G for the purpose of preventing such crimes. So this is also aligns with the maintenance of public order and prevention of offenses, also explicitly notes as grounds for exemption. So given that both A and B fall within the broad government security related exemptions, option C, both A and B, best reflects when data protection claims are overridden. Hence option C will be the correct answer in this case. Next question is, which of the following is correct? The question asks which option accurately reflects limit under data protection regime that require consent, purpose, limitation, and restriction, arbitrary use or a sale of personal data, keeping in mind that the passage is critical of broad government exemptions, not supportive of unlimited use or a sale by private entities. So the passage condemns widespread and unwarranted collection of data and notes that government is exempt from the deletion and purpose limitation in contrast to the stricter regulations on businesses. It does not authorize selling personal data or using it for whatever purpose. Such practices are precisely what data protection law is meant to control. So in case of this, option A, a personal data collected by health service provider can be sold to an insurance agency by the service provided without the consent of the concerned person. So this contradicts core data protection principles, that is consent, purpose, and limitation. Nothing in the passage suggests this is allowed. In case of option B, personal data collected by the government can be used for whatever purpose. So the passage says the government is not bound by purpose limitation and has broad exemption, but this is exactly why it is criticized as a dangerous and unbalanced. Stating it as a blanket can be used for whatever purpose as a correct legal position overstates and normalize what is criticized. In case of option C, personal data collected by insurance company can be sold to mobile companies for mobile marketing without the consent of the concerned person. So again, contrary to the data protection norms, this is precisely the kind of misuse that such a law intend to curb. In case of option D, all of the above, since each individual statement conflict with basic data protection logic and the critical tone of the passage, they cannot collectively be correct. Given the option, none is normatively consistent with the DPA's consent and purpose-based framework as described. The best exam-oriented conclusion is that this is a flawed MCQ where no option is defeasible as a correct under the principle highlighted in the passage. So such type of question can be withdrawn by the consortium as soon as the answer key is released. The Supreme Court on September 1 held that a child born of a void or voidable marriage can inherit the parents' share in a joint Hindu family property. A three-judge bench headed by Chief Justice of India D.Y. Chandrachud, however, clarified that such a child would not be entitled to right in or to the property of any other person in the family. A voidable marriage is one that is made invalid by the husband or a wife through a decree. A void marriage is invalid at its very inception. Chief Justice Chandrachud said the first step to the inheritance of a child from a void or voidable marriage would be ascertain the exact share of his parent in the ancestral property. This could be done by means of conducting a notional partition of the ancestral property and calculating how much of the property the parent would have got immediately before his death. Once the share of the deceased parent in the property is ascertained through such a notional partition, his heirs, including his children, by means of void or voidable marriage, would be entitled to their portion in the share. The Chief Justice said that Section 16 of a Hindu Marriage Act has statutorily conferred legitimacy to children born out of void or voidable marriages. In fact, Chief Justice Chandrachud pointed out that Section 16(3) stipulates that children from void and voidable marriages would have a right to their parents' property. The court said the intent of granting legitimacy to such children in the Hindu Marriage Act should also be reflected in the Hindu Succession Act, which governs inheritance. Children from void or voidable marriages come with the ambit of legitimate kinship and cannot be regarded as illegitimate by the Hindu Succession Act when it comes to inheritance. The case before the three-judge bench was focused on the amended provision in the Hindu Marriage Act, Section 13. Section 16(3), the case was referred to a larger bench in 2011 after a division bench of the Apex Court refused to follow past precedents and championed the cause of children born out of illegitimate marriages. So this passage explains the Supreme Court ruling that children born from void or voidable marriages are entitled to inherit their parents' share in a joint Hindu family property. The court clarified that while such children are legitimate heirs under Section 16 of the Hindu Marriage Act, their rights are limited to the deceased parent's share and do not extend to other family members' property. The ruling aligns with the changing social norms, recognizing these children as legitimate heirs under the Hindu Succession Act, reflecting a move away from past discriminatory practices regarding legitimacy in inheritance law. So we have a question here. Ashima and Ashok got married to each other in traditional Hindu ceremony in Kolkata, after which they both moved to USA, where Ashok had a job. In the USA, they had a child whom they named Gongol. Many years later, Ashima found that Ashok was already married to Sushma before their wedding in Kolkata. Ashok and Sushma also had a child from their marriage, Arpita, who was older than Gongol by 4 years. Ashok explained to Ashima that although he had no intention of cheating on her, he had to keep his marriage to Sushma a secret since his parents would have never agreed, as Sushma belonged to a different caste. Ashima is shocked to learn that her marriage to Ashok is void as per Hindu marriage law since Ashok was already married before their wedding. She is trying to explore possibilities so that Gongol doesn't lose his inheritance from his father's side of the family. Based on the reading of passage, what do you think is the correct position with respect to Gongol's inheritance right? So the question asks what Gongol's inheritance right given his mother's marriage was void because Ashok was already married. So the passage states children from void marriages are entitled to their deceased parents' share of ancestral property. So option A, Gongol could claim the entirety of Ashok's share of the ancestral property. This one is incorrect. Gongol gets a portion of Ashok's share only, not the entire share alone. In case of option B, Gongol would inherit the entire ancestral property as the only son of Ashok. So this one is wrong. The property belongs to the entire family and Gongol inherits only the parents' portion. In case of option C, Gongol would inherit his share from within Ashok's share of the full ancestral property without prejudice to the inheritance of other legal heir including Arpita. So in case of In case of this option, this matches the passage's precise position. In case of option D, only Sushma and Arpita are the rightful legal heirs of Ashok. So this one is incorrect. The ruling confirms Gongol also has a right despite void marriage. So as per the passage, option C is only correct option here. Let's move to the next question. In the above fact scenario, consider a property that was purchased by Ashok from his own earnings in the USA, thereby not making it part of an ancestral property, but instead falling in the category of self-acquired property upon Ashok's death, who would have inheritance right over the said property. So this question is about who inherits Ashok's self-acquired property after his death. The passage notes that children from void or voidable marriages have inheritance right over the parents' self-acquired as well as ancestral property. Hence, in case of option A, Sushma and Ashima, both mothers are heirs but children also inherit. Hence, option A is wrong. In case of option B, Sushma, Ashima, Arpita and Gongol, as they are all his rightful legal heirs. So in this case, Ashima is not a legal heir here. Mother's rights aren't emphasized in inheritance. Option C, Sushma, Arpita and Gongol. This one is correct. Children and legal first wife inherit self-acquired property. Option D says Sushma and Arpita. So this option excludes Gongol unfairly. Hence, only option C, Sushma, Arpita and Gongol is the correct answer here. Because Sushma is his first legal wife and Arpita and Gongol are the children of Ashok. Next question is based on your reading of the passage. How did the Hindu Marriage Act influence the outcome of the case on inheritance? Select one option from below. So this question asks how the amended Hindu Marriage Act, specifically section 16(3), affected inheritance right in this case. The passage mentions section 16(3) statutorily grant legitimacy to children of void or voidable marriages and mandates inheritance right under the Hindu Succession Act. So the option A, the amended provisions of Hindu Marriage Act grant legitimacy to children from the voidable marriages, and therefore this logic should be extended to children born of voidable and void marriages under the Hindu Succession Act. This one is incorrect as it includes void marriages as well. In case of option B, the amended provision of Hindu Marriage Act gives legitimacy to the second marriage, and therefore this should also have an impact on a Hindu Succession Act. So marriage itself not legitimized, but children are given legitimacy for inheritance. Option C, the amended provisions of a Hindu Marriage Act grant legitimate status to children from void or voidable marriages, and therefore this should also extend to the Hindu Succession Act. So this one is correct because it matches with passage. In case of option D, the Hindu Marriage Act has no bearing on the case in a question. So this one is wrong as it is the basis of the ruling. Hence, option C, the amended provisions of Hindu Marriage Act grant legitimate status to children from void or voidable marriages, and therefore this should also extend to the Hindu Succession Act. Next question is, 12-year-old Kausalya was married off to 23-year-old Dasharath in her maternal home in Uttar Pradesh. She completed her education after her marriage and went on to get a job as a teacher at a government school. Dashrath's family, however, was opposed to her taking up a job outside the house and insisted that she should stay at home and look after her two sons, Ram and Lakshman. Kausalya, however, was excited about starting her new job and sought advice from her younger sister, Varshini, who was training to be a lawyer. Varshini advised her that since she was married before she turned 18, her marriage was voidable and she could get it annulled. Kausalya, who was not very happy in her marriage, considers this option but is worried that her sons may lose their inheritance. Select the option that denotes correctly the status of Ram and Lakshman to inherit their father's ancestral property. So the question is whether children born of a voidable marriage retain inheritance right if the marriage is annulled. So passage state children from voidable marriages are legitimate heirs with inheritance right. Hence, in case of option A, Kausalya's children cannot inherit Dashrath's ancestral property but can inherit his self-acquired property. So this one is incorrect. Children are legitimate heirs for both property types. In case of option B, both Ram and Lakshman can inherit their father's share of the ancestral property irrespective of the voidable status of their parents' marriage. So this one is correct. This matches the ruling. In case of option C, if Kausalya decide to annul her voidable marriage, she and her son would lose all rights of inheriting ancestral property from Dasharath. So this one is incorrect. Annulment of voidable marriage doesn't affect children's inheritance right. Option D, Ram and Lakshman can only inherit ancestral property from their mother's side since she decided to annul the voidable marriage. So this one is wrong. Inheritance is through father's ancestral property as well. Hence, only option B will be the correct answer in this case. Ajay is married to two women, Diya and Riya, and both don't know of each other. He was married to Diya first when they were both around 23 years of age and studying together in college. They have no children. He later got married to Riya in a temple and she had no idea about his first marriage with Diya. Ajay and Riya have two children, Raj and Rani. One day, Riya found out about Diya from one of Ajay's college friend. She wants to divorce Ajay but finds out that her marriage to him is a void since he was already married at that time. At a loss, she goes to a lawyer to find out about the rights of her children to inherit property, which is the most legally sound advice that the lawyer could give to her. So the question is, what advice should be given about inheritance right of children from a void marriage? The passage confirms children born of a void marriages are entitled to inherit. In case of option A, he would say that her children can still inherit property from Ajay thanks to the Supreme Court judgment. This was correct and aligns with the passage. In case of option B, he would advise her to get marriage registered so that they can inherit property. So registration doesn't affect inheritance right of children born already. In case of option C, he would advise her to ignore her marriage with Ajay since it is anyway a void marriage. This one is irrelevant because children's inheritance right stands regardless. In case of option D, he would advise her to speak to Diya and sort it out with her so that her children can inherit property since she would have the final say. So this one is wrong. Inheritance is a legal matter, not about the mother's consent. Hence only option A, he would say that her children can still inherit property from Ajay thanks to the Supreme Court's judgment. This one is the correct answer here. Next question is, in above scenario, Riya wants to know if there is any way in which the judgment can come to her aid while inheriting property owned by Ajay. What would the correct position of a law? So does Riya herself as a spouse have a right to inherit from Ajay's given void marriage? The passage focuses on children's inheritance, not the spouses. Void marriages don't confer spousal rights. In case of option A, no, she cannot inherit property as the judgment merely talks about rights of children from void marriages. This one is correct. Passage indicates children's right, but spouses from void marriages has no such a claim. Hence option A will be the correct answer here. While in case of option B, yes, she should fight for her right to inherit property. This is not clearly supported. Spouse's right depend on validity of marriage. Option C says, yes, Ajay would have to give her property since he cheated on her, but the legal inheritance is not based on moral claims. Hence, this will be the wrong answer. In case of option D, she would get an equal share of property as Diya since they are both his wives who got married to him without knowing about each other. This one is wrong because void marriages does not make spouse equal legal heir. Hence, only option A is the correct answer in this case. Next question is, Smriti's first marriage was void due to being within the prohibited degree of relationship. Dhanalakshmi, who is the daughter of Smriti from her first marriage, confronts her mother once she finds her identity, demanding her share in her mother's ancestral property. Smriti, however, subsequently married Drupad and has two daughters with him, Ira and Shira, and is not interested in giving any property to Dhanalakshmi. Dhanalakshmi decides to assert her right in a court of law. How would Dhanalakshmi's share be determined? So, can Dhanalakshmi inherit Mother Smriti's ancestral property despite being born from a void marriage? This is the question here. So, passage says children from void marriages have inheritance right to notional partition. So in case of option A, Dhanlakshmi would not have any right in her mother's share of the property, since the right of inheritance pertains only to a father's share of a property. So this one is incorrect. Maternal and ancestral property inheritance is a valid. Option B says Dhanlakshmi could demand a notional partition and get a share from Smriti's portion of her ancestral property. This one is correct because it matches with the passage. Option C, being a child from void marriage, then Lakshmi has no right of inheritance. This one is wrong. Passage affirms right of such children. While in case of option D, it is Smriti's decision as to whom she gives right in her property. This one is wrong. Inheritance governed by law, not a personal discretion. Hence, only option B, Dhanlakshmi could demand a notional partition and get a share from Smriti's portion of her ancestral property is a correct answer here. So there is one passage. The 42nd Constitutional Amendment Act 1976 introduced the concept of environmental protection in an explicit manner into the Constitution through introduction of Article 48A and Article 51AG in main judgment. The Supreme Court ruled that both the state and its resident have a fundamental duty to preserve and protect their natural resources. The recent judgment obliquely makes way for an enforceable right and a potential obligation on the state unless the same is overturned by Act of Parliament. India is signatory of various international environmental conservation treaties under which India has the binding commitment to reduce carbon emission. During the COP21, India signed a Paris Agreement along with 196 countries, under which universally binding agreement was made to limit greenhouse gas emission to level that would prevent a global temperature from increasing to more than 1.5 degrees Celsius before the Industrial Revolution. India has committed to generating 50% of its energy through renewable resources and will generate 500 gigawatt of energy from a non-fossil fuel by 2030, reducing the carbon emission by 1 billion ton. Additionally, India has committed to achieve net zero carbon emission target by 2070. Supreme Court's March 21, 2024 verdict builds on the bulwark of jurisprudence since 1986, and through various other judgments, the Supreme Court has recognized the right to clean environment along with the right to clean air, water and soil free from pollution, which is absolutely necessary for the enjoyment of a life. Any disturbance with these basic elements of environment would amount to violation of Article 21. It also establishes duty of the state to maintain ecological balance and hygienic environment. Although right to clean environment has existed by recognizing the right against climate change, it shall compel the state to prioritize environmental protection and sustainable development. अगर हम इस पैसेज को शॉर्ट में समझे तो भारत ने अंतर्राष्ट्रीय स्तर पर पर्यावरण संरक्षण को लेकर अनेक संधियों पर हस्ताक्षर किए हैं, जिनमें प्रमुख है पेरिस समझौता। इस समझौते के अंतर्गत भारत ने यह बाध्यकारी वचन दिया है कि वह ग्रीन हाउस गैसों के उत्सर्जन को इतना सीमित करेगा कि वैश्विक तापमान में वृद्धि औद्योगिक क्रांति से पूर्व की तुलना में 1.5 डिग्री सेल्सियस से अधिक न हो। भारत ने यह भी संकल्प लिया है कि वह 2030 तक अपनी ऊर्जा को 50% नवीकरणीय स्रोतों से उत्पन्न करेगा और 2070 तक नेट जीरो कार्बन उत्सर्जन के लक्ष्य को प्राप्त करेगा। 21 मार्च 2024 के सुप्रीम कोर्ट के निर्णय में जलवायु परिवर्तन के विरुद्ध कार्यवाही को जीवन के अधिकार अनुच्छेद 21 से जोड़ा गया है। न्यायालय ने यह स्पष्ट किया है कि स्वच्छ वायु, जल और मिट्टी का अधिकार जीवन के आनंद के लिए अनिवार्य है तथा इन तत्वों में कोई भी विक्षोभ अनुच्छेद 21 का उल्लंघन माना जाएगा। इस निर्णय ने जलवायु न्याय के अधिकार को संवैधानिक संरक्षण प्रदान करते हुए राज्य और नागरिक दोनों पर पर्यावरण संरक्षण का समान कर्तव्य स्थापित किया है। तो स्टूडेंट्स, हम इस पैसेज के जो क्वेश्चंस है वो देखेंगे। पहला क्वेश्चन है, इन विच अमंग द फॉलोइंग चेंजेस वर इंट्रोड्यूस्ड फॉर एनवायरमेंटल प्रोटेक्शन थ्रू द कॉन्स्टिट्यूशन ऑफ इंडिया, दैट इज 42nd अमेंडमेंट एक्ट। First one is fundamental right, second one is fundamental duties, and third one is directive principle of a state policy. Okay, to solve this question, we need to find out the keywords which are given into the passage, and the keywords are 42nd Amendment, environmental protection, constitution. These are some keywords which are given in the question. So in order to locate this in the passage itself states that environmental protection was introduced explicitly through Article 48A, that is a directive principle, and Article 51A, that is the fundamental duties. So in order to extract the correct option, we have to eliminate all the wrong options, in which option A, it includes fundamental rights, which is not correct. Option B includes directive principle and fundamental duties, which is correct because Article 51A, that is fundamental duties, and Article 48A, that is directive principles of a state policy, these things are mentioned in the passage. So option B will be the correct answer, option C will be incorrect, and option D, that also going to be an incorrect option. So the fundamental duties and directive principles of state policies, these are the changes which were introduced for environmental protection through the Constitution of India, 42nd Amendment Act. The nature of binding commitment of India to reduce carbon emission through the signing of various international environment conservation treaties, especially the Paris Agreement, may be described as options are given. The signatory shall take adequate measures to reduce carbon emission. The signatory may take adequate measures to reduce carbon emission. The signatory should explore the possibility to reduce carbon emission, and the signatory may formulate necessary policies to reduce carbon emission. तो यहाँ पे क्वेश्चन में दिया है बाइंडिंग कमिटमेंट that implies mandatory action, and the passage state that universally binding agreement was made to limit greenhouse gas emission, and India has a binding commitment. So the option A, shall take adequate measures, that reflects a binding duty. Option B, may take, that means it is optional or not binding. Option C says should explore, it means it is not binding. And option D, may formulate policies, it means it is a discretionary. So the signatory shall take adequate measure to reduce carbon emission. Option A will be the correct answer here. Under Article 51AG of the Indian Constitution, it is specifically mentioned that citizens shall have the duty to protect and improve the natural environment. That includes, options are given, rivers and lake, forest and wildlife. Option C, all living creatures. Option D, only A and B. So the passage explicitly covers rivers, lakes, forest and wildlife, not just a living creatures. So option A, rivers and lake, is a partial. Forest and wildlife is also partial. यहाँ पे भी आधा दिया है. Option C है all living creatures, which is incomplete, and option D जो है उसमें है lakes, rivers, forest and wildlife, that matches the text. Only A and B will be the correct answer here. Let's move to the next question. As per the aforementioned passage and decision of the Supreme Court, option A, the fundamental duty to preserve and protect natural resources is upon the state only. Option B, citizens alone have the fundamental duty to preserve and protect natural resources. Both the state and citizen have the duty to preserve and protect natural resources. And last option is state's duty to maintain ecological balance and citizen right against climate change. So as per the passage, both the state and resident have a fundamental duty to preserve and protect the natural resources. It means both the state and citizens, ये दोनों की जिम्मेदारी है to protect and preserve the natural resources. Option C, both state and citizen, which will be the correct answer. According to the passage, what makes India committed to reduce carbon emission? Options are given: because of being a signatory of International Environmental Conservation Treaty. Option B, because of Supreme Court's verdicts, which obliquely makes way for an enforceable right. Option C, because of policy decisions of government. And option D, because of the Constitution of India, that is 42nd Amendment Act. Okay, the passage says India is a signatory of various international environmental treaties. India signed the Paris Agreement. It means because of being a signatory, India is committed to reduce carbon emission. So option A, because of being a signatory, that matches the text. Supreme Court verdict, that is related but a secondary. Option C, government policy, that is derivative. And option D, 42nd Amendment, that is a domestic and non-international. That's why option A, because of being a signatory of International Environmental Conservation Treaty, will be the correct answer here. Let's move to the next question. The passage mentioned that any disturbance with these basic element of environment would amount to violation of Article 21. Article 21 of the Constitution deals with. Options are given: right to equality, right against exploitation, right to freedom of residence, and option D, right to life and personal liberty. So let's eliminate options. So right to equality is as per Article 14 of Indian Constitution. Exploitation is related to the Article 23 and 24. Freedom of residence, that is related to the Article 19(1)(e), and right to life and personal liberty is related to the Article 21. So the option D, right to life and personal liberty, will be the correct answer. We will read the passage. Geographical indications, GIs, are a form of intellectual property that designates a product as originating from the specific geographic location where a given quality, reputation, or other characteristic is essentially attributable to its geographic origin. GIs protect names that are used to identify product with specific qualities or characteristics due to their geographic origin. For example, Champagne refers to a sparkling wine produced in the Champagne region of the France, and Darjeeling tea refers to tea grown in the Darjeeling region of India. The protection of GIs ensures that only products genuinely originating from the specific regions are allowed to use the geographical name. This helps maintain the product's reputation and quality, prevents misuse or imitations, and supports local economies by promoting regional products. International agreements such as TRIPS agreement under the World Trade Organization, that is WTO, provides a framework for the protection of GIs globally. So basically this passage explains geographical indications, that is GI, as an intellectual property rights that protects product names linked to a specific place when the product's quality or reputation are essentially due to that origin. It illustrates with example like Champagne and Darjeeling tea, noting that GI protection ensures only genuine regional product can use the name, thereby preserving reputation, deterring imitations, and supporting local economies. It also states that international protection for GIs is provided under the WTO TRIPS agreement, which sets minimum standard and enforcement mechanisms for member countries. So let's see questions. Which of the following statement about geographical indications, that is GI, is not true? Options are given. Option A, GIs are protected under international law to ensure that only products from the specific regions can use the GI name. The use of GI name can be legally challenged if it is used by a product not originating from the specified region. Option C is given. Geographical indications, that is GI, can be used to any product which is licensed regardless of its place of origin. Option D, the TRIPS agreement under the WTO establishes a framework for the protection of GIs on the global scale. So guys, we can simply locate relevant portion of this question in the passage. So as per passage, GIs protects only product from the designated regions and the TRIPS framework for GI protection. So on the basis of passage, we can eliminate some choices such as option A. As it says, GIs are protected under the international law to ensure that only product from the specific region can use the GI name. It is true. In case of option B, the use of GI name can be legally challenged if it is used by the product not originating from the specific region, which is also true because misuse can be legally challenged and prohibited. In case of option D, the TRIPS agreement under the WTO establishes a framework for the protection of GIs on the global scale. It is also true because TRIPS establishes a global framework for GI protection. While in case of option C, geographical indications, that is GI, can be used to any product which is licensed regardless of its place of origin. This one is not true. A GI cannot be used for any licensed product regardless of origin. Origin is essential. Hence the option C will be the correct answer here. Let's see next question. If the product name Darjeeling tea is produced outside of the Darjeeling region, which of the following legal action is likely to be taken under GI protection law? So we have options here. The product can still be sold but with the disclaimer about its true origin. Option B, the use of a GI name that is Darjeeling tea can be legally contested and potentially prohibited. Option C, the product can be sold under a different GI name of non-Darjeeling tea. Option D, the product can be marked as a Darjeeling tea and will face no legal consequences. So guys, as per the passage, GI misuse can be contested and Darjeeling tea is a protected GI. Hence, we can eliminate option A, which state the product can still be sold but with a disclaimer about its true origin. So this can be eliminated because disclaimer does not cure GI misuse, still it will be infringing. Hence option A is eliminated. Option C, the product can be sold under the different GI name of non-Darjeeling tea. This also can be eliminated because not Darjeeling tea as a GI is a meaningless and not permitted to evade protection. In case of option D, the product can be marketed as Darjeeling tea and will face no legal consequences. This one is incorrect because it will going to face some legal consequences. But in case of option B, the use of GI name Darjeeling tea can be legally contested and potentially prohibited. This one is correct because use of Darjeeling tea outside the region can be legally contested and prohibited. Hence, option B will be the correct answer here. Next question is, which of the following is not a potential consequences of misuse of geographical indications? Options are given. Option A, loss of consumer trust in the authenticity of the product. Option B, decrease in the market value of the GI protected product. Option C, compulsory license on the patents of the misusing entity. And option D, potential legal action of infringement against the misuse. So we can simply locate in the passage, misuse lead to loss of a trust, economic or brand value will also going to decline. So the compulsory licensing relate to patent, not GI. So on the basis of this, we can eliminate option A, which says loss of consumer trust in the authenticity of the product, because loss of consumer trust occur with the GI misuse. In case of option B, decrease in the market value of a GI protected product, so it will also be a consequence because decrease in the market value or a brand dilution will going to occur. In case of option D, potential legal action of infringement against the misuse, this one is also being a consequence of a misuse of a GI because legal action infringement remedies are standard. Hence option C, compulsory license on the patents of a misusing entity, it is not a consequence because compulsory license on patent is unrelated to the GI misuse. Hence option C will be correct answer here. Let's see next question. In the context of GIs, which of the following scenarios best illustrate the concept of geographic origin? Option A is given, a product name is changed to reflect its local ingredients rather than its place of production. Option B, product is marketed with the GI name even though it is produced in a different region and country. Option C, a product is identified by GI name that correspond to the region where it is traditionally made or cultivated with distinctive qualities due to that location. Option D, a product is sold under the generic name with no reference to its production location. So we can simply locate this in passage. GI identifies products whose qualities or reputation are due to origin. Hence, on the basis of this, we can eliminate option A. It says a product's name is changed to reflect its local ingredients rather than its place of production. Because changing name to reflect ingredient, not origin, misses the point. In case of option B, a product is marketed with the GI name even though it is produced in different region and country. So marketing with the GI from different region is a misuse. It is not an illustration. In case of option D, a product is sold under generic name with no reference to its production location. So in this case, generic name with no location reference does not illustrate GI. Hence option C, a product is identified by GI name that correspond to the region where it is traditionally made or cultivated with distinctive qualities due to that location, is a correct because GI respond to the region where traditional production occurs and qualities are due to that place. Hence option C will be the correct answer here. Let's move to the next question. Choose the most appropriate objective of a TRIPS agreement concerning geographical indications. Option A is given to harmonize intellectual property laws across member countries. Option B to ensure uniform product labeling standards globally. Option C to provide a framework for the protection and enforcement of geographical indication among WTO members. And option D to promote international trade by standardizing product names and prices. So in case of this, TRIPS set minimum standard and enforcement for IP including GIs among the WTO members. So on the basis of this, we can eliminate option A because broad harmonization is not the most precise objective here. In case of option B, it is also can be eliminated because product labeling standards are outside TRIPS core scope. Option D also can be eliminated because standardizing names and prices is not TRIPS function. Hence option C will be correct because TRIPS provides a framework for protection and enforcement of GIs. Hence option C is the Contract Act 1872 deals with the contract law in India, its rights, duties and exceptions arising out of it. Section 2H of the Act gives us definition of a contract, which is simply an agreement enforceable by law. To understand the difference between void agreement and voidable contract, it is important to talk about section 2H, 2A, 2I, 2D, 14, 16, 3 and 15 with 24 to 28 of the Indian Contract Act. Void agreements are fundamentally invalid, making them unenforceable by the default. These agreements cannot be fulfilled as they consist of illegal element and they cannot be enforced after subjecting it to both parties. However, in the case of voidable contract, the agreement is initially enforceable, but it is later on denied at the option of either of the parties due to various reasons. Unless rejected by a party, this contract will remain valid and enforceable. The party who is at the disadvantage due to any circumstances applicable to the contract has the ability to render the agreement void. A void agreement is void ab initio making it impossible to rectify any defect in it, while voidable contract can be rectified. In case of a void agreement, neither of the parties is subject to any compensation for any losses, but voidable contract have some remedies. A valid agreement forms a contract that may again be either valid or voidable. The primary difference between void agreement and voidable contract is that a void agreement cannot be converted into contract. So let's see the short passage summary. The passage explains the different type of agreement and contract as per the Indian Contract Act of 1872. It emphasizes the distinction between void agreement and voidable contract. Void agreement are invalid from the start, which is a void ab initio, illegal and unenforceable, meaning they cannot be rectified or enforced under any circumstances. Typically, neither parties receive a compensation for losses arising from such agreement. Voidable contracts are initially enforceable but can be rendered void at the option of one party due to specific circumstances, allowing remedies and rectification unless rejected by a party. A valid agreement may be either voidable or valid, but a void agreement cannot be converted into a valid contract. The passage also references relevant sections of the Act explaining these differences. Let's see questions. Which of the following best describes a void agreement? Options are given: an agreement that is valid until declared invalid by a court, an agreement that has no legal effect from the beginning. Option C is an agreement that is legally enforceable, and option D, an agreement that can be enforced if one party chooses to do so. So guys, the keyword in this question is void agreement and best describes. So the relevant portion of this passage will be a void agreement is void ab initio to impossible to rectify. So we can eliminate option A because valid until declared invalid, it is a false, as void agreements are invalid from start, which is ab initio. We can eliminate option C, that is legally enforceable, because it is incorrect. Void agreements are not enforceable. Similarly, in case of option D, that also can be eliminated can be enforced if one party chooses it is wrong, they cannot be enforced. So the best option for this question will be option B, an agreement that has no legal effect from the beginning. So the correct option will be option B. Next question is a contract between two parties to rob a bank and share the proceeds equally can be termed as. Options are given: void contract, valid contract, voidable contract, and legally enforceable contract. So guys, let's see keywords: rob a bank, share proceeds, and contract. So relevant portion for this question in the passage is agreement involving illegal acts are typically void. So we can eliminate option B, valid contract, because it is impossible since it involves a crime. Option C can also be eliminated because voidable contract does not apply as illegal agreements are inherently void, not voidable. Similarly, in case of option D, we can also eliminate this option which says legally enforceable, which is incorrect. So the best answer for this question will be option A, void contract. So the correct answer will be option A. Let's see next question. An agreement made by an adult but involving a minor child where the signatory is a minor child himself. This agreement would be. Options are given: a valid and enforceable agreement. Option B is given a voidable agreement. Option C is given void agreement. And option D, an agreement that cannot be enforced by the minor. So guys, let's see which are the keywords. The keywords are agreement and minor. So the relevant portion for this question will be some agreements with minors are void, others are voidable. So we can eliminate option A because valid and enforceable, it is incorrect. Minors cannot contract validly. Similarly, in case of option B, voidable agreement, it is possible as minors contract can be voidable. Option D, agreement that cannot be enforced, it is possible, but the question asks the nature of agreement. So the best answer will be option C, a void agreement, because generally minors agreement are invalid or void, making this the most suitable choice. So the option C will be the correct answer here. Let's move to the next question. Which of the following scenarios would likely result in a void agreement? Options are given: an agreement signed by someone under duress. Option B, a contract with mutually agreed terms to sell a house. Option C, an agreement to pay 10 lakh on getting a government job. And option D, a contract with a minor who understand the terms. So guys, let's see which are the keywords given. So keyword is void agreement and most likely. So relevant portion of this passage for this question will be illegally and breach of law usually produce a void agreement. So on this basis, we can eliminate option B as it says sale of a house, it is illegal and enforceable. Option C, payment on getting a government job, which is likely illegal or at least questionable and could lead to void agreement. Option A can also be eliminated. Signed under duress might be voidable but not necessarily void. So the best answer will be option A, agreement signed by someone under duress, as a duress makes an agreement void ab initio. So the correct answer will be option A. Let's move to the next question. An agreement made with the consideration is generally. Options are given: valid agreement, enforceable agreement, void agreement, and voidable agreement. So students, keywords are without consideration and generally. So relevant portion of the passage for this question will be such agreement are typically void unless exceptions apply. So we can eliminate option A, valid agreement, because generally it is incorrect. Enforceable agreement, it is also can be eliminated because only if exceptions apply, not normally. In case of option C, void agreement, it is correct for general cases. Option D, voidable agreement, exceptions exist but generally void. So the best answer will be option C, void agreement. Passage discuss how children interact with the criminal justice system either as a victim or a witness. or as a children in a conflict with the law. It also highlights a recent data from the National Crime Record Bureau, that is the NCRB report 2021, showing trends in crime against children in India, especially in categories like kidnapping, abduction, and cases under POCSO Act. The passage further explains the main objective of the criminal justice system, which include deterrence and punishment of offenders. Finally, it details the risks children face when involved with the criminal justice system, including trauma, abuse, and limited opportunity. Children come in contact with the criminal justice system either as a victim or a witness to a crime or as a children in conflict with the law, that is CICL. As CICI, they could be alleged of accused or reorganized as having broken the law by committing a crime. According to the National Crime Record Bureau NCRB report 2021, India recorded a total number of 1,49,404 instances of crimes against children in the 2021, a rise of over 16% from the previous year. In terms of percentage, the top categories under crime against children were kidnapping and abduction, followed by cases registered under the POCSO Act. Further, the NCRB report revealed that of the total cases, 53,874 were registered under POCSO section. Sexual offences against children shows a steady ascent, with the 47,221 such cases being recorded in 2020 and 47,335 cases in 2019. In 2019, as many as 32,269 cases were registered across the country, while the 2021 report registered a decline of 3.5%, recording 31,170 cases. The criminal justice system of any country broadly referred to agency of the government charged with the enforcing law, adjudicating crimes, and correcting criminal conduct. The main objective of the criminal justice system is deterrence, that is to punish the transgressor and the criminals and to maintain law and order in the society. Globally, children and young people are routinely exposed to various forms of violence if they are before the criminal justice system. They are at a risk of physical and psychological abuse, sexual assault, and other harms, including inadequate educational opportunities, poor and outdated vocational training. They face several challenges, including mental, emotional, and behavioral disorders. Children who are victims of violence or exposed to violence during the childhood are more likely to have difficulty in school, abuse drugs or alcohol, act aggressively, suffer from depression or other mental health problems, and engage in a criminal behavior as adults. So let's look at the question 1. Which of the following issues children who are victim of violence during childhood face in a life as per the author of the above passage? The options are: they may have difficulties in school, they may abuse drug or alcohol and suffer from mental health problems, they may act aggressively and engage in a criminal behavior. And option D is all of the above. So let's break it down. First, we look for the keywords in the question: issues children face, victim of violence, and as per the author. So these are some important keywords in the question. Now let's go back to the passage. The relevant part says, children who are victim of violence or exposed to violence during childhood are more likely to have a difficulty in school, abuse drug or alcohol, act aggressively, suffer from depression or other mental health problems, and engage in a criminal behavior as an adult. So this is the relevant part. The options A, B, and C are explicitly mentioned since the question asks which of the following issue they face, and all are correct. So the best answer is D, all of the above. Now the question is, what is the primary objective of the criminal justice system as mentioned in the passage? We have options here: rehabilitation of offenders, punishment of offenders, reformation of the offenders, protection of the victims from offenders. So guys, the keyword is primary objective and criminal justice system. We have to look for these words in the passage. So the passage says the main objective of a criminal justice system is a deterrence, that is to punish the transgressor and criminals and to maintain law and order in the society. Let's go to the options. So the main focus is on punishment and maintaining order. rehabilitation, and reformation are not mentioned as a primary objective, and while victims' protection is important, it's not stated as the primary goal. So the correct answer will be option B, punishment of the offenders. Let's go to the next question. Question number 3. The National Crime Records Bureau, that is NCRB in India, is responsible for option A, conducting forensic investigation of records of criminals, maintaining a national database of fingerprints of criminals, compiling and analyzing crime data, maintaining a national database of enforcement of a criminal laws. So the important keywords are National Crime Record Bureau in India. So what are their responsibility? We can look into the passage. So this passage cites the NCRB report of 2021, which means NCRB compiles crime data. It does not mention forensic fingerprints or enforcement directly. So the correct option will be compiling and analyzing crime data. That is option C. Let's go to the next question. Which category had the highest number of cases under crime against children according to the NCRB report 2021? Options are given. Option A, POXO. Option B, kidnapping and abduction. Option C, sexual offenders. Option D, all of the above. So the passage says in terms of a percentage, the top categories under crime against children were kidnapping and abduction, followed by cases registered under the POXO Act. So the correct answer will be kidnapping and abduction. So the option B will be the correct answer. Let's move to the next question. Which one of the following is the correct expansion of the term POXO used in the passage? We have options here. Option A, protection of children from sexual offenses. Option B, prosecution of criminals of sexual offenses. Option C, protection of children and women from sexual offenses. None of the above. So guys, as we know, the passage discusses sexual offenses against children and the POXO sections are mentioned in this context. So the correct answer or the correct expansion is widely known and matches the context here. That is option A, protection of children from sexual offenses. So the option A will be the correct answer. Let's move to the last question of this session. What risk do children face when exposed to the criminal justice system as per the passage? We have options here. Limited access to vocational training, exposed to a risk of physical abuse, mental health challenges and behavioral disorders, and all of the above. The passage itself says they are at a risk of a physical and psychological abuse, sexual assault and other harms, including inadequate educational opportunities, poor and outdated vocational training. They face several challenges including mental, emotional and behavioral disorders. So it means children are at a risk of a physical and psychological abuse, sexual assault and other harms, including inadequate educational and vocational training. They also face mental, emotional and behavioral disorders. So all three options which are given are supporting. So the correct answer will be option D, all of the above. So guys, we worked through a 6 class. The Public Examination Prevention of Unfair Means Act 2024 that has provision for up to 5 years imprisonment and fine up to 1 crore for malpractices and organized cheating in a government recruitment exam was notified by the Union Government and came into effect from June 21, 2024. The bill had received assent from the President of India on the 13th February 2024. The Public Examinations Act 2024 mentions punishment for leakage of question paper or answer key, directly or indirectly assisting the candidate in any manner unauthorizedly in public examination, and tampering with the computer network or a computer resources or a computer system. As the offense is done by a person, group of person or institution, beside these, creation of fake website, cheat or for monetary gain, conduct of fake examination, issuance of fake admit cards or offer letter to cheat or for monetary gains, and manipulation in seating arrangement, allocation of dates, shifts for the candidate to facilitate adopting unfair means in examination are also among the offenses punishable under the law. Any person or persons resorting to unfair means and offences under this act shall be punishable with imprisonment for a term not less than 3 years but which may extend to 5 years and with fine up to 10 lakh. Said the Act, the service provider engaged by the Public Examinations Authority for conduct of examination shall also be liable to be punished with imposition of a fine up to 1 crore, and proportionate cost of examination shall also be recovered from it. According to the Act, such service provider shall also be barred from the being assigned with any responsibility for the conduct of any public examination for a period of 4 years. So let's summarize this passage. The Public Examination Act 2024 came into the effect on June 21, 2024. Its primary goal is to combat organized cheating and malpractices in a government recruitment exam. The Act prescribes severe punishment, including imprisonment for 3 to 5 years and fine up to 10 lakhs for individuals involved in unfair practices. For service providers like firm engaged to conduct exam, the penalties are even stricter, with fine up to 1 crore, recovery of examination costs, and 4-year ban from the handling public exams. So key offences listed in this Act include leaking question papers or answer key, assisting a candidate unauthorizedly, tampering with the computer system related to the exam, creating fake website or conducting fake exam, manipulating seating arrangement or exam schedules to facilitate cheating. So there are some questions. Question is, a bill become an act only when option A is given, both the houses of parliament pass with the simple majority, both the houses of parliament pass with the absolute majority, when the Prime Minister of India gives his approval, when the President of India gives the assent. So as per the passage, the second sentence states the bill had received assent from the President of India on 13th of February 2024. This implies that the bill was transformed into act upon the President assent. So we can eliminate some options here. Option A says both the houses of the parliament pass with simple majority. This is a crucial step in the legislative process, but a bill does not become an act solely upon being passed by the parliament. It requires the president assent to become a law, hence this is incorrect. In case of option B, both the houses of the parliament pass with the absolute majority. It is similar to A. This is a procedural step, but not the final step for the bill to become an act. Furthermore, the passage often requires a simple majority. This option will also be incorrect. In case of option C, when the Prime Minister of India gives his approval. So the Prime Minister approval is not a constitutional requirement for bill to become an act. The head of a state, the president, gives the final assent. This is incorrect. And option D says when the President of India gives the assent, this is the correct final step as per the Indian Constitution, and it is directly supported by the information in the passage. So option D will be correct answer here. Let's move to the next question. The question is, a service provider engages by the public examination authorities for conduct of examination indirectly helped his family member by giving hint on a questions that were supposed to be asked in the examination shall, option A is given, be liable to be punished with the imposition of a fine of 1 crore, be liable to be punished with the imposition of a fine up to 1 crore. Option C, be liable to punished with imposition of a fine up to 1 crore and the entire cost of a conduct of the examination, and option D, none of the above. So in this case, we can locate the portion in the passage. The relevant part is the service provider shall also be liable to be punished with the imposition of a fine up to 1 crore and proportionate cost of the examination shall also be recovered from it. So we can look for the correct answer here, in which option A says be liable to be punished with imposition of a fine of 1 crore. This is incorrect because it states a fixed fine of 1 crore. The law specifies a fine up to 1 crore, meaning the amount can be less and is at the discretion of the court. Option B says be liable to be punished with the imposition of fine up to 1 crore. So this is partially correct but incomplete. The passage clearly states that in addition to the fine, the proportionate cost of examination shall also be recovered. This option misses the crucial part of the penalty. Option C says be liable to be punished with the imposition of a fine up to 1 crore and the entire cost of the conduct of the examination. This is also incorrect because of the word entire. The law specifies proportionate cost, not necessarily the entire cost. So the word entire makes this option too extreme and inaccurate. Hence option D, none of the above, will be the correct answer here. So we can move to the next question. An invigilator of a public examination found guilty of manipulating the seating arrangement to favor his relative writing the public examination is punished by the court. Which among the following is the appropriate punishment as per the punishment mentioned in the above passage? We have options here. Option A is imprisonment for 1 year and fine of 1 lakh, imprisonment of 2 year and fine of 10 lakh, imprisonment for 3 year and fine of 15 lakh, and option D, imprisonment for 4 years and fine up to 5 lakh. So for this question, the passage states any person or a persons resorting to unfair means and offences under this act shall be punished with imprisonment for a term not less than 3 years but which may extend to 5 years and with fine up to 10 lakh. So on the basis of this, option A, imprisonment for 1 year and fine of 1 lakh, this is incorrect because the minimum imprisonment mandates by the act is 3 years. So 1 year is below the statutory minimum. In case of option B, imprisonment of 2 years and a fine of 10 lakh, this is also incorrect because again the imprisonment term for a 2 year is below the mandated minimum of 3 year. In case of option C, imprisonment of 3 year and fine of 15 lakhs, this is incorrect because the fine of 15 lakh exceeds the maximum fine of 10 lakh, which is specified for the individuals in this act. Now, in case of option D, imprisonment of 4 year and fine of 5 lakhs, this is correct. It falls perfectly within the prescribed range. Imprisonment is between 3 to 5 years and the fine is within the limit up to 10 lakh. Hence, option D will be correct answer here. Because the act sets a strict punishment range for individuals, the imprisonment must be minimum of 3 years and the fine cannot exceed 10 lakh. So only option D satisfies both these conditions simultaneously. Let's move to the next question. Identify which of the following is not an unfair means relating to the conduct of a public examinations. Options are given. Option A, coaching center conducting mock test for a student. The passage lists various offenses. We need to find the option that is not mentioned as an offense in the passage. For this option, coaching center conducting mock test for a student, this is a standard preparatory activity. The passage does not list conducting mock test as an unfair means or an offense. So this is likely the correct answer. In case of option B, the coaching center offering help to its student during the examination, this directly falls under the directly or indirectly assisting the candidate in any manner unauthorizedly, which is a listed offense. In case of option C, the center superintendent of a public examination on the request of the coaching center provides a seating arrangement of all its students in one hall. So this is a clear example of a manipulation in seating arrangement to facilitate adopting unfair means, which is punishable offense. In case of option D, the center superintendent of a public examination indirectly assisting the candidate. This explicitly mentioned as an offense under the category of directly or indirectly assisting the candidate. So the best answer will be option A. While a coaching center might be involved in malpractices, the act of conducting mock tests itself is a legitimate educational and preparatory activity, and it is not classified as an unfair means. Under the described act, all other options describe an action that are explicitly listed as an offense. So the option A will be correct answer here. Let's move to the next question. Who among the following is not a service provider in the context of a public examination? So the passage defines a service provider as one engaged by the public examination authority for the conduct of examination. So in case of option A, coaching center which prepares student for passing in the public examination. So in case of this option, a coaching center is a private entity that prepares student independently. It is not formally engaged by the examination authority to conduct examination. Therefore, it does not fit the definition of a service provider under this act. Hence, option A will be the correct answer. In case of option B, printing press where the question paper of a public examination is printed, In case of this option, the printing press is directly engaged by the authority for a critical part of conducting the examination. This fits the definition of a service provider. While in case of option C, the software company that manages the website of the public examination, this company is engaged by the authority to manage a key resource for the exam. This fits the definition of a service provider. In case of option D, the company which scans the OMR sheets of the public examination. So this company is also engaged by the authority for the post-exam evaluation process. This also fits the definition. Hence, option A will be the correct here, because the key phrase is engaged by the public examination authority for conduct of examination. A coaching center operates independently and is not contracted by the government to conduct any part of official examination process. Its role is purely preparatory and external. The other option are all examples of external firms or companies that would be hired by the examination body to perform a specific official task which is related to the examination administration. Hence, option A going to be a correct answer here. So guys, you have just completed another set of legal aptitude PYQs. One of the most is a fundamental right, and that the right to informational privacy is part of this right. Subsequently, the Parliament of India enacted a new law relating to digital personal data protection. The law applies to Indian resident and businesses collecting the data of Indian resident. It also applies to the non-citizen living in India whose data processing is in connection with any activity related to the offering of goods or services that happens outside India. The law allows personal data to be processed for any lawful purpose. If the personal data is sensitive, then additional safeguards are to be observed. The entity processing data can do so either by taking the concerned individual's consents or for legitimate use, which include a situation where an individual has voluntarily provided personal data for the specified purpose. The law requires that an individual's consent must be free, specific, informed, unconditional, and ambiguous, with the clear affirmative action, and for a specific purpose. The data collected has to be limited to the necessary for the specific purpose. A clear notice containing these details has to be provided to consumers, including the right of the concerned individuals and the grievance redressal mechanism. Individuals have the right to withdraw consent if consent is the ground on which data is being processed. The law also creates rights and obligations for individuals. These include the right to get a summary of all collected data and to know the identities of all other entities, organizations with whom the personal data has been shared. Along with a description of the data shared, individuals also have the right to correction, completion, updating, and erasure of their data. Besides, they have a right to opt in redressal for their grievances and a right to nominate persons who will receive their data. So let's summarize this passage. This passage explains the key provision of Indian Digital Personal Data Protection Law enacted after the Supreme Court recognized privacy as a fundamental right. The law governs how the personal data of individuals in India is processed. It mandates that data processing must be for a lawful purpose and require entities to obtain a clear, informed, and specific consent from individuals, except for certain legitimate use. The law emphasizes transparency through clear notices and grant individuals significant right, including the right to access, correct, and erase their data, the right to know with whom their data has been shared, and the right to grievance redressal. So let's discuss questions. An Indian company collects personal data from its user to provide a personalized service. The company intends to share this data with the third-party vendor for targeted advertisement under the Digital Personal Data Protection Law in India. What must the company do before sharing the data? So first we have to understand the question. The question is asking for the primary legal prerequisite for sharing users' personal data with the third party for new purpose, that is targeted ads. So the passage states that the law requires that an individual's consent must be free, specific, informed, unconditional, and Unambiguous, with a clear affirmative action and for specific purpose. Sharing data with the third party vendor for advertising is a new specific purpose that was not part of the original consent for personalized services. Let's see what are the options here. Option A is obtain explicit consent from the users. This one is correct since the purpose is new and specific. The company must obtain a fresh explicit consent as defined by the law. Option B says share the data by informing the users that it is for business purpose. This one is wrong. A mere notification is insufficient. The law requires explicit consent for such actions unless it falls under the narrowly defined legitimate use, which is scenario does not clearly state. So option B will be wrong here. In case of option C, encrypt the data and share it with the third party vendor. This one is also wrong. While encryption is a good security practice, it is not the legal prerequisite for sharing the data. The law's first requirement is legal basis for processing such as a consent. While in case of option D, inform the third party vendor that the data is sensitive. This one is wrong. This is irrelevant to the legal obligation toward the users from whom the data was collected. So the question focuses on company's duty to the users. So out of all these options, as we discussed, option A will be the correct, because since the purpose is new and specific, the company must obtain a fresh explicit consent as defined by the law. Let's move to the next question. A social media platform processes users' data based on the consent given during account creation. A user now wishes to withdraw consent to process their data under the Digital Personal Data Protection Law in India. What must the platform do? So first see what is asked in this question. This tests your understanding of the user's right to withdraw consent and the corresponding obligation of the data processor. So the passage explicitly states individuals have the right to withdraw consent if consent is the ground on which data is being processed. So let's look for the correct option. Option A says refuse to accept the withdrawal request since the consent was already given. This one is wrong. This directly violates the fundamental right to withdraw consent granted by the law. Hence option A will be wrong here. In case of option B, comply with the legal requirement and stop processing the data, this one will be the correct. The right to withdraw consent is a meaningless without a corresponding obligation to stop processing. So withdrawing consent removes the legal basis for the processing. While in case of option C, continue processing the data but notify the user. This one is wrong. This is the opposite of what the law requires. Processing must stop upon withdrawal. In case of option D, allow withdrawal only after 30 days. This one is wrong. The passage does not mention any mandatory cooling off or waiting period for withdrawing a consent. Hence option B, comply with the legal requirement and stop processing data, will be the correct answer here. So let's move to the next question. A financial institution collects biometric data from its client for verification purpose. If the client wishes to know what data has been collected under the Digital Personal Data Protection Law in India, what right allows them to request this information? So in this case, you need to identify which specific right empowers an individual to ask for a summary or a details of the data that has been collected about them. So the passage lists the right, including the right to get summary of all the collected data and to know the identities of all other entities or organization with whom the personal data has been shared. So let's look for the correct answer. Option A says right to data portability. This one is wrong. The passage does not mention a right to port or a transfer data to another controller. In case of option B, right to correction, this right deals with the correcting inaccuracies, not initially accessing what data exists. It will also be wrong. In case of option C, right to access, so the right to get summary of all the collected data is classically known as right to access in data protection regimes. Hence, this one will be the correct answer here. In case of option D, right to be forgotten, this is related to the right to erasure, which comes after one has accessed and reviewed the data. Hence, this one will be wrong. So the correct answer will be option C, right to access Let's move to the next question. A startup provides a health tracking app that collects sensitive health data from users under the Digital Personal Data Protection Law in India. What additional precautions must be startup tech compared to regular personal data? So in this case, this question checks your understanding of the heightened protection required for the sensitive data compared to the regular personal data. So the passage itself states, if the personal data is sensitive, then additional safeguards are to be observed. So in case of option A, no additional measures are needed. This is directly contradicts the explicit statement in the passage, hence it will be a wrong option. In case of option B, ensure explicit consent and adopt higher security standard. While not itemized in this passage, this is the logical and legal implication of additional safeguards. It implies a stricter standard for a consent and stronger security measures to protect the sensitive nature of the data. Hence, this one will be the correct answer here. In case of option C, store the data only with the government agencies. The passage does not mandate any specific storage location like a government agency. Hence, option C will be wrong here. In case of option D, store the data only with the hospital. So similarly, the law does not restrict storage only to the healthcare institution. Hence, this one also be wrong. Hence, only option B will be the correct answer here. Ensure explicit consent and adopt higher security standards. Let's move to the next question. As per the passage, what are the rights included under the Digital Data Protection Law of India? 1. A right to get the summary of collected data. 2. Right to know to whom the data has been shared. 3. A right to correct and update the data. 4. A right to get the data removed from the database. 5. A right to decide on who can receive their data. And 6. Right to get redressal of grievances. So this is a comprehensive check to see if you can correctly identify all the rights explicitly listed in the passage. So let's verify each number against the text. So first one is right to get summary of collected data. It is explicitly stated. Second one, right to know to whom the data has been shared. It is also explicitly stated. Third one is right to correct and update the data. This is also present in the passage. Fourth one, right to get data removed from the database. It is also mentioned in the passage. Fifth one is right to decide on who can receive the data. This is also stated in the passage, right to nominate person who will receive their data. Sixth one is a right to get redressal of grievances. It is also stated in this passage. Hence, option D, 1, 2, 3, 4, 5 and 6 correct. All 6 are directly mentioned in the passage. So guys, that's all for today's session, Legal Reasoning MCQs. I hope the detailed explanation helped you understand how to approach passage-based and factual questions with confidence. For full-fledged preparation, join Global Online's live CLAT batch, which include daily live classes, complete notes, mock test, doubt clearing and exam guidance. And make sure to get Global Online's Law CET and CLAT book. It includes complete syllabus coverage, chapter-wise explanation, topic-wise practice questions, previous year papers and model tests, smart tips and tricks for quick revision. The purchase link is in the description. Like, share and subscribe to stay updated. See you in the next video. Thank you.